Respectfully stated, each of you swore an oath to uphold the Constitution. And if you don't understand the provisions that you swore to uphold, then you're not fit for office. A high school student can understand what is an office of trust, and continued feigned ignorance evidence is treason to the Constitution.
He did ask to be recognized again because he shared that he had new information. I do need, from a disclosure standpoint, to say that John is in litigation with the state of Tennessee. And so, John, it's very customary for us when that's the case. We don't try to get involved in any of the litigation. You're very welcome to speak, and I think you told my assistant that you could probably do it all within 9 minutes, and so you're now recognized, so thank you.
Thank you, Chairman. My name is John Gentry. I trust that the members here have the same love of this republic and your fellow man that I have. I'm here today to assert my rights to instruct and to remonstrate unlawful conduct by address. As members, you have inherited some incredible mistakes from your predecessors, mistakes that have unlawfully altered our form of government and that cause great harm to the citizens of the state. Our first step must be to correct the Tennessee Constitution on these houses' website held out to the people. I hereby instruct you to correct the false version of the Tennessee Constitution. Your continued refusal to do so is treason to the Constitution, and it's violation of your oaths of office. The last phrase of Article 1, Section 23, I have viewed the original 1870 and 1834 Constitution with my own eyes in the archives. The last phrase says, by address or a remonstrance, or remonstrance. We have a choice. And that language has been altered in the PDF version held out on the Secretary of State and the General Assembly websites. There is no fault in you for inheriting mistakes. However, now knowing to not correct those mistakes is to perpetuate them, making you guilty as principal in treason to the Constitution and in violations of your oaths. For this committee to approve these rules is evidence of a desire to conceal judicial criminal conduct from the public and to continue an unlawful alteration of our fundamental form of government. Rule 0102, subparagraph 1 and 2, chair and vice chair to be elected from the members of the board. Members of the judiciary cannot hold second offices of trust, and they cannot be members of this agency. It is clearly prohibited in Article 6, Section 7, that no judge shall hold any other office of trust. Last hearing on this matter, I proved that members of the judiciary and members of the Board of Judicial Conduct are holding prohibited offices of trust. I'll explain again in Q&A if you want me to. During last hearing, it was suggested that I hire an attorney if I want to invalidate the Board of Judicial Conduct. It is ridiculous to suggest that I petition the judiciary about restoring judicial oversight that they don't want. These houses do not need an attorney or a judge to tell you what is an office of trust. It is common sense. Respectfully stated, each of you swore an oath to uphold the Constitution. And if you don't understand the provisions that you swore to uphold, then you're not fit for office. A high school student can understand what is an office of trust, and continued feigned ignorance evidence is treason to the Constitution. Beyond prohibited offices, any agency created outside of these houses for the purpose of judicial oversight is to forsake the Constitution and your duties as representatives. And I challenge you to ask me why. And I'm going to say that again. Any agency created outside the House for purpose of judicial oversight is to forsake the Constitution and your duties as representatives. And again, I challenge you to ask me why. Rule 0102, subparagraph 3 states that the chairperson shall preside at all meetings of the board and at trials. Rule 103 states that matters that come before the board are confidential. If a judge or a member as a chair is presiding over a trial, this board is a court, and pursuant to Tennessee Constitution, Article 1, Section 17, all courts shall be open. But this agency, with its star chamber, covert, dark court proceedings caused by its rules, are repugnant to the Tennessee Constitution. Rule 0104, records retention. Both a physical and electronic file shall be created. The physical file shall contain the complaint and all relevant documentation. Why use the word relevant? Why not simply all documentation? The reason that it reads all relevant documentation is so that tricky attorneys can decide what is relevant, and it permits them to conceal parts of the record. The electronic record then only contains relevant portions of the complaint. This means that the complaint itself can be edited down to decide whatever is relevant. And the worst part of this rule, 0104, voluminous records such as transcripts, court dockets, or pleadings need not be scanned to the electronic file, and a physical file may be destroyed after 1 year of final disposition. Why wouldn't a court record, transcript, evidence be kept with the complaint, except to confound the preservation of the evidence of crimes perpetrated by judges? The clear intent of this agency, evidenced in its rules, is to conceal corrupt conduct of judges. What should be, and as required in our state constitution, all complaints against judges should be made to their district representatives, then filed with the House clerk, and then referred to the Judiciary Committee for presentation by the complainant to the committee. All documents tendered with the complaint, including the complaint itself, and all correspondence must be scanned and preserved electronically. All documents must be made available to the public, searchable by district, county, and judge. Criminal conduct must be referred to the full House for impeachment and misconduct for removal. The citizens of Tennessee do not desire a state government to conceal from public view the evidence of criminal conduct of judges, nor to unlawfully prevent the exercise of legislative power. The latest quarterly report for this reconstituted agency now proves that these rules continue to result in 100% dismissal of complaints filed by non-legal professionals, and that this agency is same old, grossly negligent oversight. And Senator Roberts, you recognize the negligence of this agency, that negligence persists. I see no change in the judiciary whatsoever, and I hear from a lot of people across this state. These rules resulted in the mere suspension of Judge Woodrow Adams after grand jury indictment on 3 counts of child rape. With these rules, this agency doesn't even bother to submit to the House for impeachment proceedings so as to preserve false public trust of our corrupted judiciary and to prevent exercise of legislative powers. These rules themselves, proposed by this agency, are repugnant, and for Judge Gay to tender these rules renders him unfit for office. Taken together with his obvious conspiracy with Senator Bell to silence my testimony last hearing on these rules, he should be impeached. I accuse Judge Gay and Senator Bell of federal crime in violation of 18 U.S.C. Section 241, conspiracy against rights, and I demand to address the full body in memorial and remonstrance. Representative Hardaway agreed the words of Senator Bell did not ring true, and Representative Daniel shared the same concern. Who among you will file a brief statement with the clerk so that I may address the body? Show of hands. And let the record show that I see no hands. It is legislative power to remove and impeach judges and provide oversight of the judiciary. This is common sense based on Article 5 and Article 6 of the Constitution that you swore to uphold. Judicial oversight is a duty of the House, a duty House members fail to perform at great cost of society. The founders were clear that it's the duty of the House as a check and balance of the judiciary to provide judicial oversight. Any judicial agency, comprised of judges or not, is repugnant to the Constitution and dissolves the check of one branch over the other. I've gone on I'm probably getting close to my time, and I have more, but I am grateful, and I want to express my gratitude to the body here for allowing me to be quite frank and candid today and allowing me this time.
Thank you. Representative Hardaway, did you wish to be recognized?
Absolutely. And I want to go on record. Nothing that I have said today, yesterday, or any other day to suggest that Senator Bell is guilty of any crimes or guilty of any negligence in carrying out his duties. Whatever discussion that the gentleman and I had was primarily around his right to be heard. And I still support that, but I don't appreciate being written into whatever your other agenda is in terms of the allegations that you have against a judge and against a senator.
Thank you, Representative Hardaway. Are there any other questions for Mr. Gentry? So, briefly, yes.
My apology to Representative Hardaway if I misunderstood what he said. It's on the Legislative House, and he said that he didn't understand why I was here and the judge wouldn't, and that the words of Senator Bell didn't, and I quote, ring true. There's more to the story as to why I'm making that accusation, but that would be brought forth in a remonstrance if allowed.
Thank you. Thank you, and thank you for being here today. Any other public comment? Thank you, Mr. Gentry. Any other public comment before us today? I do want to make a comment. I know we're going to be recognize somebody for a motion in a minute, but I want to make sure I'm able to make a comment before that happens. Yes, Senator Pody.
Thank you, Chairman. I do have a question for legal, and that question is concerning the Constitution, Article 6, Section 7. Is this in any way a violation of that?
Doug Garrett with Legal Services. Senator Pody, I'll have to check that. I don't have an answer for you, but I will be glad to get back to you on it.
Chairman Daniel, you're recognized.
Thank you, Chair. And Senator Pody, I just looked at the Constitution. I think the question here revolves around whether the positions that the judges have on the board is a position of trust, is an office of trust, and that there's actually several Attorney General opinions on this, which I'd like to look at, but nothing on point. And frankly, I have doubts as to whether your position on the board is an office of trust. I think that's the question. Thank you.
I just want to say, Mr. Gentry, I'm going to recognize you one more time, but then your public comment period is over, okay? And briefly, please.
Yes, extremely grateful to you for that. So what is an office of trust in response to Representative Pody? Black's Law Dictionary, 10th edition, a position of trust, duty, or authority, especially one conferred by a governmental authority for public purpose. Citing a treatise on the law of public offices and officers from the year 1890, Section 16, Office of Trust, an office whose duties and functions require the exercise of discretion, judgment, experience, and skill is an office of trust, and it's not necessary that an officer have the handling of public money or property. Citing Eliot's debates, James Wilson, Pennsylvania Ratifying Convention, December 4, 1787, the incompatibility clause, and that's prohibited offices, seeks to prevent corruption by ensuring that the mere acceptance of an office effectually destroys the end for which it was offered. And Cornell Law Review 1994, one person, one office. The incompatibility clause was motivated by worries about British-style corruption, and the framers did not perceive it as having much to do with the separation of powers. And the opinions from the Office of Attorney General should have no sway, because these are just attorneys that want to preserve oversight of attorneys in black robes. And well, I won't get into litigation on this, but the Office of Attorney General has behaved fraudulently.
Okay, thank you, and I appreciate you being here today, and that concludes the public comments. Are there any other comments from members before I make my comment? I will go ahead and just simply say that this reconstitution of the Board of Judicial Conduct came about because probably every elected official in front of you has had complaints about the judiciary. And despite the mechanism in place to remove judges or discipline judges, we very rarely see that activity. There were some of us who were not I'll just use the expression, we're not excited about this reconstitution. Some of us thought maybe a different approach would be more effective, but nonetheless, this was the approach that was put forward and, of course, passed legislatively. I think I can speak for every legislator on this committee when I say, and anyone in disagreement is welcome to speak up, that we hope that this reconstitution will very quickly result in evidence that the judiciary is very serious about rooting out judges who are incompetent or who are corrupt or who otherwise violate their oath of office. So we would love to be in a position, and we get complaints about a lot of the same judges. And I think I've joked before that when you talk to a teacher at a school and ask them who the good teachers and the bad teachers are, they always know. And I think in the cases of the judiciary, you all probably know who's a strong judge and who's a weak judge. And I hope that this reconstitution will be an opportunity for the General Assembly to see that we're on the right track here. So I hope that that's taken in the spirit with which it's offered, because I want Tennessee to have the very best judiciary that it can be. And I think we all know that in many cases we probably have some outstanding judges, but we also have some that don't need to be behind the bench. And it's time to recognize and identify who those are and take the appropriate action. Senator Bell, you're recognized. Okay. Any other comments? The chair will entertain a motion. Make a motion for a positive recommendation. And do we have a second on that? We have a second from Chairman Daniel. Any comment on the motion itself? Madam Secretary, if you would, please do a roll call vote in the Senate, please.
Senator Bell? Votes aye. Senator Bowling?
Aye.
Votes aye. Senator Crow? Senator Jackson? Aye. Votes aye. Senator Kyle? Senator Pody? No. Votes no. Senator Powers? Aye. Votes aye. Senator Rose? Aye. Votes aye. Chairman Roberts? Aye. Votes aye. Mr. Chairman, you have 6 ayes, 1 no.
Thank you. Do we have a quorum in the House? I believe we do. I know some members had to leave, but I believe they're all back. So we're 2, 3. Yes, we do. Okay, we'll do a voice vote in the House. All those in favor of a positive recommendation say aye. Aye. Those opposed, please say no. No. The ayes have it, and it moves forward with a positive recommendation. Thank you all for being here today, and hopefully you'll be able to get back to Sumner County in time to preside over your trial.
Thank you.